Hello students, welcome to the Recitals in-depth. In this session, we are going to discuss the important topics that are featured in the section of Polity and Governance for the month of May 2024. The topics that we are going to cover are broadly following under the themes of Parliament, Elections, E-Governance, Local Governance. So recently, the Supreme Court of India provided a very important judgment. It held that the advocates cannot be sued by their clients under the Consumer Protection Act for any kind of deficiency of services, or if the clients had felt that the services which has been provided by the advocate is not up to the mark. And the Supreme Court held that the services which are being provided by the advocate does not fall under the definition of services which has been provided in the Consumer Protection Act. So to know more about this particular case, let's go to the next slide. So we'll start with the background. So the Supreme Court was hearing a petition against the 2007 judgment of National Consumer Disputes Redressal Commission. So what judgment does the National Consumer Disputes Redressal Commission has provided in the year 2007? It has provided that the services which are provided by the advocates fall under the definition of services. Definition of services under Section 2 Clause O of the Consumer Protection Act of 1986. So it was almost a 18-year-old case, and in that particular judgment, the NCDRC, it held that the services which was provided by the advocates, these services fell under the definition of services which was provided by the Section 2 Clause O of the Consumer Protection Act of 1986. However, one important point to note over here, that the Consumer Protection Act of 1986 was repealed and it was replaced by the Consumer Protection Act of 2019. Why did the government bring this new act? To actually reflect the new social, technological and economic realities any individual faces as a consumer. However, one also important point to note over here is that the entire essence of the Consumer Protection Act of 1986 was transposed into Consumer Protection Act of 2019. However, with certain minor changes to bring in certain new kinds of businesses and trades like e-commerce, etc. So, the definition which was provided by the Consumer Protection Act of 2019 is same as the definition which has been provided by the Consumer Protection Act of 1986. However, it is the services definition is provided in the Section 2 Clause 42. Now, what Supreme Court held in going against the judgment which has been provided by the National Consumer Disputes Redressal Commission is that the Supreme Court held that the services which are being provided by the advocates do not fall under the definition of the Consumer Protection Act, whether be it Consumer Protection Act of 2019 or whether be it Consumer Protection Act of 1986, because ultimately these the definition of services which these two acts are providing are the same only and they have been copied. So, to understand the major nuances of this particular case, let us try to understand it from the point of view of the Section 2 Clause 42 of the Consumer Protection Act of 2019 itself. So, this particular subclause 42 provides the definition of service or the term service, and ultimately this particular definition of service comprises of three major elements. First is descriptive element. I will explain it. What do we actually understand by descriptive element? Second is inclusionary element. And last is exclusionary. So when we'll read this thing, so service means service of any description which is made available. Service of any description. That this definition is keeping the scope of the definition, that this terminology is keeping the scope of the definition to be very, very broad. That any services can be actually regarded as to be considered as service under the definition which has been provided by this particular act, and this is called the descriptive portion of this particular definition. Now, as we'll read further, What do we actually mean by the inclusionary aspect of this definition? So this definition which has been provided by the Act, it actually enlists, it objectively enlists certain kind of services, for example, banking, financing, insurance, transport, processing, supply of electrical energy, etc., amusement, etc., to be labeled as services itself. And that is why it is called the inclusionary part of the definition, that it is including, very objectively it is including the categories of services which will be labeled as services. And lastly, it is also containing the exclusionary part, that what does not come into the definition of services under this particular Act. So the particular section reads, but does not include rendering of any services free of charge or under a contract of personal service. So two important points we need to note over here under the exclusionary aspect of the definition of services which has been provided by the Act. First of all, no such service will be called as a service which has been given free of charge. So if any vendor is providing any service to any particular customer free of charge, and if that particular service is not up to that particular standard or mark, then it will not be labeled as like service. And secondly, if a service is under a contract of personal service, and this is the primary segment that we need to understand over here. Okay, now what the Act also says, that if any particular service falls within the definition of this service provided by the particular Act, and if a customer or the person who has availed the service is not happy with the quality of service that he has received, then he can definitely approach the consumer courts of our country, whether be it at the district level, whether be it at the state level or at the central level, so that they can get certain compensation out of this particular case. And this is what has happened with respect to the lawyers in our country, that it has been a very dominant view that even the advocates were suggesting that the services which has been provided by the lawyers should not be included in the definition which has been provided by the Consumer Protection Act. And what are the major reasonings which has been provided by the advocates to keep their services out of the ambit of Consumer Protection Act is what we are going to discuss in the coming section. So the major argument or the reasoning which has been given by the lawyers to exclude themselves from the Consumer Protection Act is that they highlighted that the legal profession is very unique in nature. By highlighting that it is very unique in nature, it says that suppose there is an advocate and there is a client. So client is giving the money, and in return of it, it is providing them a service of advocacy. However, what body of lawyers it suggests, that just because there is a transaction of cash, the advocate or the lawyer in this particular case is not only bound to actually serve the particular client itself, because a lawyer is enmeshed in a grid and it is responsible to a lot of stakeholders. So it is responsible to its own client, it is responsible to the bar council, it is responsible to the constitution of our country, and it is also responsible to the legal precedents. So just because there is an exchange of cash and there has been a contract of service, that is why the term which had appeared in the legal definition, that the contract of service, it does not mean that a lawyer has to, or all the actions which a lawyer will take will be absolutely in line with whatever its client is suggesting. And ultimately this the lawyer is absolutely enmeshed in various stakeholders, and it owes responsibility to other stakeholders as well. And while performing lawyer's duty towards the constitution or towards the Bar Council of India or towards the legal precedents of our country or to the performing its duties towards the courts, there might be a possibility that he will not be able to do absolute justice which is there in mind of the particular client. The second important point which has been highlighted by the lawyers, or the reasoning which has been provided, that there is no one particular standard operating procedure or a benchmark with which all the clients will be able to identify whether they are satisfied with the services availed by them by the advocate. So since legal profession which rests on advocacy, and advocacy is not very scientific and mechanical, it is based on storytelling, and every lawyer and advocate has their own style of advocacy, and there cannot be one single parameter of judging the performance of a particular advocate. So that is why, since there is no one particular standard or standard operating procedure or a basic benchmark, no consumer who is availing the services of an advocate will be able to actually identify that whether they have availed good services or not. And thirdly, the third major important point is that the legal outcome is extremely complex. Since the legal processes are extremely complex, since it involves a lot of laws, complex provisions of laws, legal precedents, so it is extremely hard and it is extremely difficult to actually judge and predict the outcome of a particular case. And whenever a client is losing the case, so they will would be wanting to actually go to the consumer court, because in their idea their particular advocate has not performed well. And the fourth point which the advocates have provided is that the conduct or the professional conduct of advocates is already regulated by the Advocates Act of 1961, and there is no need for bringing a more redundant step by bringing the professional conduct of the advocates under the Consumer Protection Act. These were the top 4 major legal arguments which are provided by the body of lawyers in front of the Supreme Court. And what did the Supreme Court say with respect to this? So what was the Supreme Court's observation in the judgment? So Supreme Court, first of all, it identified and it acknowledged the unique nature of the legal profession. And what did it mean by the unique nature of legal profession is that Supreme Court held that while dealing with various legal cases in the court of our country, whether be it local courts or in the Supreme Court or the High Courts, an advocate in news or an advocate who is performing the services is not only helping his client to win that particular case, but that particular advocate at the same time is also setting precedents for the entire country, precedents for various other lawyers and precedents for the laws and judicial pronouncements. And that is why it is extremely difficult for any lawyer or an advocate to perform in the best of its capacity according to the benchmark which is present there in the mind of the clients. The second point it had noted, or the Supreme Court provided, is that the legislative intent of the Consumer Protection Act of both 2019 and 1986, the intent was never to bring in professions like medical practitioners and advocates under the ambit of Consumer Protection Act. However, since the Supreme Court held that the definition of services which has been provided by the Section 2 Clause 42 of the Consumer Protection Act, the services provided by the advocates or the lawyers does not fall or comply with the definition of the services which has been provided in the Act, because the services which is being provided by the lawyer, ultimately it is falling under a contract of personal services. And what do we actually understand by contract of personal services? A contract of personal services is a sort of it can be understood as a sort of a master-slave relationship. What do we understand by that? So whenever a client is actually hiring an advocate to take or to avail their advocacy in front of the court, a advocate in this case cannot actually undertake or any furnish any kind of evidence without the consent of the client. So in the court proceedings, it is the client which dictates how and what kind of evidences and what kind of documents will the advocates will be furnishing. And that is why ultimately there is a master-slave relationship. There is a master-slave relationship with respect to the client and advocate relationship, and it is the client which governs the major trajectory and the composure and scope of the legal proceedings which are being taken in the court. And that is why the Supreme Court of our country held that the services which are being provided by the advocates of our country will fall under the contract of personal services, and it is excluded from the definition of services. And lastly, the Supreme Court also held that the third point, that in its 1995 judgment, which was a three-judge bench judgment, it had brought the medical practitioners under the ambit of Consumer Protection Act, and in this particular judgment, the Supreme Court held that it must be reviewed, it must be revisited by a larger judge bench as soon as possible. So this was the entire legal issue with respect to this particular case. So recently, India achieved a great feat by establishing almost 2 lakh public Wi-Fi spots under the PM-WANI scheme. So what is this PM-WANI scheme? What does it stand for? How does it work? And what are the various stakeholders involved? And what kind of benefits can be availed through this thing? This is what we are going to discuss in the coming slide. So PM-WANI scheme is a short form for Wireless Access Network Interface. This is the full form of the scheme called PM-WANI. Now, few important points that we need to know over here is that it's a flagship scheme of the Department of Telecommunication, which was launched in the year of 2020. To do what? So it has been launched to proliferate the adoption of broadband services. Broadband services means fast internet connectivity. Okay, so it means fast internet. So that is the agenda. But how it is trying to proliferate the various broadband services? With the help of public Wi-Fi spots. And to whom it is trying to convey? So it is trying to reach out to those people who are underserved in urban areas and rural areas, since the internet penetration is quite low in the rural areas as compared to the urban areas. Now, one of the major problem, what is the major problem which this particular scheme is trying to solve? The major problem which PM-WANI is trying to solve is the problem of last mile delivery. What happens is that whenever an internet service provider, for example, let's take the example of Jio. Jio is an internet service provider. Jio is able to lay down the optical fibers and they can create a mesh of optical fibers throughout the major part of the city. However, when it comes to taking the internet to every remote places or remote households, it is an extremely difficult problem for all the internet service providers, whether it be Jio or whether it be BSNL for that instance. And that is why PM-WANI, what it wants to achieve is that it wants to leverage the basic infrastructure which is present over there in such remote localities to be acting as public Wi-Fi spots, so that the problem of last mile delivery can be very easily tackled and dealt with, so that the remote locations or the remote infrastructural facilities which are present in any underserved urban areas or any rural areas will be able to act as a Wi-Fi spots, and then they will be able to provide faster internet connectivity to the users which are present in their particular vicinity. So to understand the functioning of PM-WANI, we need to understand basically the various stakeholders which are associated with the scheme of PM-WANI. So ultimately there are 4 major stakeholders which are present in the PM-WANI ecosystem. So this is the PM-WANI ecosystem, and ultimately there are 4 stakeholders which are actually promoting and facilitating the proliferation of broadband services with the help of public Wi-Fi spots. And how does it work? So we need to understand, before we go on and understand the various technicality of it, let us try to understand how PM-WANI works with a very simple example. So let us try to assume that this is a street and there is a crossing. So there is almost a crossing of 2 major streets are going, and there is a possibility that there is a shop in this corner, which can be a very normal mom and pop shop, that is the normal kirana shop. So what happens is that there are many households which are located over here to the nearby, and similarly this road is the only major road which passes through this particular village. Let us assume this is a particular village, and there is one shop which is there in the middle of the market, or in a proper market where there is a habitation or nearby habitations are there. So what PM-WANI is trying to do is that ultimately the internet service provider has provided a tower over here which is quite far from this isolated habitation. Now what the core and the central idea behind PM-WANI is that it is trying to leverage the potential infrastructure which this mom and pop shop is having, that this particular shop will act as a Wi-Fi hotspot, and the internet services which will be provided by this particular shop will be utilized by these households which are lying in the vicinity of this particular shop, because it will be economically not viable to actually lay down optical fiber to every household which is located in a very isolated conditions and locations. And that is the central idea behind the PM-WANI scheme. And to actually provide it with again more clarity, so the mom and pop shop that we actually witnessed is nothing but a PDO, which is called Public Data Office in technical terms. What is public data office? So public data offices are nothing but the infrastructure or the Wi-Fi hotspots. So these mom and pop shops or any smaller shops, or it can be a public panchayat office, or it can be a primary healthcare center. So these buildings can act as a public data offices whose main work will be to establish, maintain and operate PM-WANI compliant Wi-Fi hotspots, and to provide what the faster internet services by addressing the problem of last mile connectivity, so that every customer or any customer which is lying in the vicinity of that particular infrastructure, they will be able to access the internet by logging in to the Wi-Fi hotspot which has been provided by the PDO, which is public data office. And this public data office, however it sounds technical, to understand it in a more layman terms, it can be any infrastructure. It can be a private shop, it can be a panchayat office, it can be a primary healthcare, or it can be a hospital. But these bodies will leverage the infrastructure which is present with them to actually broadcast the Wi-Fi, so that the other users which are living in the vicinity, they will be able to tap into that faster internet services which has been provided by the PDO. Now the second stakeholder which is present in the PM-WANI ecosystem is PDOA, which is a short form for Public Data Office Aggregator. As the name suggests, aggregators, usually when the PM-WANI functions, these PDOA are nothing but internet service providers itself. So these internet service providers, for example Airtel or Jio, so these either Airtel or Jio, they will come up with very attractive business models and plans for Wi-Fi, and they will try to woo number of PDOs in very segregated and spatiated localities, so that these PDOA will be able to provide them their internet services and in case they will be earning revenues from the PDO, which they will be earning from the consumers who will be consuming the data which will be disseminated by the PDO. However, the third important aspect which we need to know over here is the app provider. App provider is another third stakeholder which will create an app or the software ecosystem through which the PM-WANI will function. Now, whenever suppose there is a home which is acting as a PDO. So as soon as if a person, this is acting as a PDO, so it is transmitting Wi-Fi, and as soon as this person wants to access this thing, so this person should be having a proper app which is known as PM-WANI app. Now, because of this PM-WANI app, they will be able to see the nearby PDOs or the public data offices which are in the vicinity of that particular customer, and the customer will be able to choose from the list of PDOs, and whoever will be the PDO, and if the PDO is offering very good prices to the customer, the customer will go with the lowest price offering. So whoever will be the PDO, if he or she is offering lesser prices for the data, so definitely this particular person will choose that PDO itself. And lastly, the fourth stakeholder is the central registry. So the major work of the central registry is to maintain the details of the various app providers, PDOAs and the PDO, so that there has to be a proper accounting with respect to what kind of transactions of revenue and internet data services is being taken place with respect to the users, PDO and PDOAs. Now, let us try to understand this thing with the help of a schematic diagram only. So, as we already discussed that there can be a very minuscule pawn shop, a very basic pawn shop, and this pawn shop, with the help of the PM-WANI scheme, it can transform its pawn shop not only to do basic transactions of various kind of articles which this guy is selling, but they can also create such kind of Wi-Fi infrastructure, Wi-Fi internet infrastructure, so that any passerby or a person who is living in the vicinity will be able to tap into the services which is providing. So what are the benefits that we can actually expect from the functioning of the PM-WANI scheme? First of all, to the users, of course, definitely it is going to provide very fast internet in the form of broadband services. Secondly, competitive data pricing. And thirdly, it has the power to leverage remote infrastructure to become Wi-Fi hotspots. And lastly, it will augment income of people who are involved in this particular scheme, because this person who was selling pan will now be able to generate more additional stream of revenues and income by selling Wi-Fi to the potential customers. And for India, for a as populous as country like India and as geographically diverse country like India, if we really want to proliferate and increase the penetration of fast internet services like broadband, PM-WANI scheme is bound to go a long way in helping India gain maximum penetration of internet. So recently, a case of sexual harassment was filed against the governor of West Bengal, who goes by the name of CV Anand Bose. But the police of the West Bengal were not able to file that particular case because of the various constitutional immunities which has been provided to the governor of our country. And what is that particular article which provides the constitutional immunity? It is the Article 361. And in this coming slide, we are going to discuss exactly the same. So, what does the Article 361 says? So, the Article 361 provides immunities to both President and the Governor, that they shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties, which simply means that both President and Governor are not answerable to the courts of our country while performing their official duties and obligations. So this article, basically Article 361 Clause 1, it basically propounds the concept of separation of power, and it means that the court, which is the judiciary, should have no business in actually interrogating the function of the president or governor, which is the top executives of our country. So it is basically strengthening the doctrine of separation of power in our country. What does the Article 361 Section 2 deals with? That no criminal proceedings whatsoever shall be instituted or constituted against the president or the governor in the state in any court during his term of office. So, for example, had there been a case that C.V. Anand Bose, who is a governor of West Bengal, so there can be a very simple question in UPSC Prelims examination, that since we already know that no criminal proceedings can be initiated against that governor since his term is continuing, but can there be a case outside the High Court of that particular state? So the constitution is quite explicit that there cannot be any criminal proceeding in any court in the country during his term of office. And third point is, no process of arrest or imprisonment of president and governor can be initiated by any court. So no criminal proceedings and no process for imprisonment or arrest can be issued by any court of our country. And lastly, with respect to the civil proceedings, at least 2 months notice has to be provided if there is any case of personal malefied, and if any person is involved in a civil litigation dispute with the governor or the president of our country, then that particular person has to provide, or the court has to provide, a 2-month notice to the president or the governor before initiating a civil proceeding against the president or the governor. Now you must be thinking that why such kind of discriminatory behavior with respect to the other ordinary citizens, or why does this Article 361 provide such kind of power to the president and governor of our country? Now we need to understand that these officials like the president and the governors are not usual or routine officials. These are the most powerful and most important political functionaries of our country, and they hold a lot of majesty and dignity. So the primary intent of providing such kind of article in our constitution is to uphold the majesty and dignity of these political functionaries. The second point is that since India is following a parliamentary form of government where the president is unelected, there might be a situation that the president is not functioning in line with whatever the prime minister or the council of ministers is saying, because there might be a possibility that the council of ministers is advising the president which is not in line with the political precedents or the legal precedents of our country. So in that case, to allow the presidents and the governors to function without fear or favor, that is why such kind of provisions have been provided. And lastly, since president is the topmost executive body of our country and it is the symbol of Indian state, so to foster political stability so that no ordinary citizen can one day knock the doors of the court to actually drag president to the court of our country, and it can happen. So to actually avoid such kind of things and to maintain political stability, the Article 361 has provided such kind of provisions in its ambit. However, what does the Supreme Court has said in its previous judgments with respect to Article 361? So, there has been a judgment by the name of Rameshwar Prasad versus Union of India in the year of 2006, where the Supreme Court had reiterated the various provisions which has been provided in the Article 361, and it had held that that the president and the governor, they cannot be involved in any kind of criminal proceedings till they are serving their particular term. So this is there for this particular topic. So the next topic for discussion is history sheets. From the name, it is quite suggestive of the fact that it is related to history. But history of what? So from the name itself, it is quite confusing in nature, and that is what we are going to discuss in this particular article. So before we go on and discuss the things, first of all, we need to understand that this particular topic falls into a broader theme of criminal justice system. And what do we actually understand by the history sheets? So ideally, history sheets are nothing but a basic documentation with respect to a police station where they try to document the name of various criminals associated in that particular region. Now, why at first place that we are trying to read and understand and learn this particular topic? So recently, the Supreme Court of our country, it directed all the states and union territories to direct their police organizations or police institutions to maintain the history sheets in such a manner that it should not reflect the caste prejudices and religious prejudices. So why did the Supreme Court at first instance had to direct all the state governments to direct their police to create and document the history sheets in such a manner so that it should not create any prejudice against any particular community or a particular social group? For that, for us to understand it better, we need to understand what is history sheet, how is it designed, what are the legal provisions behind it, and let us try to unfurl it in the next slide. So, what is a history sheet? As we discussed briefly, that history sheet is nothing but a documentation. Documentation which is made by whom? Which is made by the police station of a particular area. And what does it contain? It contains the name of all such criminals. It contains the name of all such criminals or persons who are accused in conviction of offences for multiple number of times. So this list contains the name of the people who are engaged or involved in the conviction for multiplicity of crimes. Crimes like theft, robbery, dacoity, etc. The kind of crime can also be related to organized crime as well. What is the legal provision behind this particular history sheet? So, the Police Act of particular state, as we know that the police is a matter enlisted in the entry list number 2, that is the state list of our Indian Constitution, and police as a matter of subject is under the jurisdiction of the state government. So every state government has created their own state police act. So the history or the legal provisions which governs the regulation of the history sheets in every state is governed by the police act of that concerned state government itself. Now, one very important also thing we need to note over here is that as soon as any person who is living in any particular area where there is a police station, so as soon as a person is convicted of multiple crimes and petty crimes like theft, dacoity or robbery, so it automatically starts the history sheet of that particular individual. Apart from it, if the station house officer or the police officer or the police wing of that particular area, they also feel that this particular person or a criminal who is convicted for a certain set of crimes is still engaging in a lot of criminal activities, then they might start or put the name of that particular accused or that particular criminal into the history sheet. Now, since as we already discussed, that the Supreme Court had directed all the state governments that the history sheets has to be maintained in a proper manner and it should not reflect and highlight the prejudices of the system with respect to a particular social group. But why did the Supreme Court tell or direct the state governments in that regard? Because we need to know what kind of content does the history sheet is actually containing, because from that content itself or the details of that criminal or the accused person, the system or the police system is trying to perpetuate the prejudices. So to begin with, what does the history sheet contain? It contains matters of personal information. Personal information means your name, your Aadhaar card, your address, your telecommunication number, etc. Apart from it, it contains your occupational details as well. That where is that particular person who has been put in the history sheet, where he is actually occupationally occupied, so that the police will be able to know whether that person is earning more than their means of livelihood or he is living at par with the means of livelihood. Apart from that, the history sheet also notes down the associates of that particular convict. What do we mean by associates? What are their friends with whom that particular person was involved in the various kind of crimes, or what kind of associates that particular person was carrying. Apart from it, they also list the details of their financial lives as well. For example, what kind of property these people are having, what kind of like extended property or immovable property these kind of convict people are having, so that with the help of these like the list of information about that accused person, the police will be able to track these particular accused criminals or history sheeters. And lastly, it also notes some kind of surveillance data as well. For example, it will note about the movement of a particular person. So whenever a person is lodged or a details of a person is lodged in the history sheet, that person is called as history sheeter. And according to, as we already noticed, that the regulation of the history sheets in our country is governed by the state police acts. So there is a lot of variety and diversity in which how the regulation of history sheets is actually being taken place in the entire country. However, there has been established practice which is prevalent across all the states of our country, that whenever a person has been put into the history sheet, then they have to report to the police station, their concerned police station, in a very frequent amount of time. Now, it will be very logical question to ask that ultimately what is the purpose of creating such kind of history sheet, and why does the police want to create such kind of history sheet, and for that purpose they are trying to delineate such kind of information from that particular convict or criminal. So this can be understood with a very simple analogy, as it happens in a classroom also. That you must have noticed that in a classroom there are always some kind of students who are troublemakers. So whenever there is some kind of noise or any disturbance which is going on in the classroom, so the teacher is going to come and pick those troublemakers only, so that ultimately the teacher, that particular teacher, will be able to make the amends in the quickest way possible. And same analogy can be put over here, that what police is trying to do is that by already identifying and getting to know what are the troublemakers present in that particular locality, they will be able to do their job better, that is of crime prevention. So ultimately the purpose is threefold. Firstly, to identify the criminal elements in the society, or the criminal elements which are present in that particular location. Secondly, to create a surveillance network. That is, if we know that certain kind of people are more prone to engage in certain kind of criminal activities, it will be very important from the resource point of view of police organization that they will be able to deploy their resources to actually create surveillance over those selected set of individuals who are maintained in the history sheet. And thirdly, one of the most important function of police of any state is the prevention of crime, because ultimately if we will be able to identify the potential criminals or the person who might engage in criminal activity in the future, and secondly, if we'll deploy proper surveillance facilities vis-a-vis those particular persons, the police will be able to do their fundamental job of prevention of crime. However, one important thing we need to note over here is that how does the process start, or how does one person ends up landing in the history sheet or being labeled as a history sheeter. So it starts with, as we already discussed, that the history sheet is being maintained in every police station, and in India we follow a regional approach to policing. That, say for example, if this is a city, there will be different thanas or police stations which are located at every locality or habitation. So what will happen is that history sheet will be maintained for every police station individually. Okay, so there will be history sheets will be maintained for every police station. Now, as soon as the SHO of any police station, SHO is a short form for Station House Officer, and SHO is generally the in charge of that public of that police station. So as soon as the SHO gets a cognizance of a particular person or an accused, and he gets to know that this particular person is convicted and involved in various criminal charges ranging from theft, dacoity, burglary, intimidation, breach of peace, etc., And then the SHO or the station house officer, if he is reasonably convinced that this person is of like doubtful and dubious character and this person might engage in criminal activities further again in the future, then this SHO puts the name of that particular person in the history sheet, and secondly, he sends that particular very detailed documentation of that particular person to the senior superintendent of police of that particular district. So this is the basic procedure which has been provided in the police rules of various police acts, which have been usually uniform across the country. Now, as we know that the role and the job of police is not easy. A lot of criminals actually lurk in our society, and there are multiplicity and numerous amounts and numbers of criminals which actually go on in our society creating trouble. So what the police is also doing is that they are trying to maintain different kinds of history sheets. So what do we mean by that? They are trying to maintain different kinds of history sheets based on the categories and the categories of crime in which the particular accused criminal is involved. So the first kind is the known depredators sheet. Known depredators, also known as KD in short. What does it mean? It involves the name of people who are accused and convicted in multiple offences multiple times. So the keyword is multiple offences and multiple time. So these people are put in the sheet called known depredators sheet. The second sheet is suspect sheets. Suspect sheets. So what do we mean by the suspect sheets? It contains the name of such criminals or accused persons who have been convicted only once. Convicted only once. Now there is a third kind of sheet which is also known as rowdy sheets. This sheet contains the names of those people who are involved in that public breach of peace. Breach of peace, and it contains the name of people who get involved in public fights, when they try to intimidate and threaten any other people. Intimidate and threaten some other people. There is also a sheet of organized crime which contains the name of such convicts or criminals which are involved in organized crimes like drug trafficking, human trafficking, money laundering, etc. And lastly, there is a sheet of budding criminals as well. So as we know that budding talent, so whenever a police also comes to cognizance that certain kind of individuals or if there is any teenager who is showing that kind of inclination that he might indulge into some kind of criminal activities in the future, so that is why the police names that sheet as budding criminals, and it hosts the name of such criminals or accused persons or individuals who are not yet convicted, but they are definitely going towards or inclining towards committing of crimes in the coming time. Now, as we already discussed, the various facets with respect to the history sheets, the legal provisions with respect to the history sheets, what does it actually contain, and now let us try to understand what is this present case about and why did the Supreme Court ask various state governments to maintain that the history sheets by the polices, it should not reflect the caste and the religious prejudices. So what had happened is that there is an AAP MLA, which is Aam Aadmi Party MLA, by the name of Amanatullah Khan. So he was charged in various cases, especially in the 2019 rioting in the Delhi, and the police of Delhi, they actually included his name in the history sheet. And this, about the news of this particular item that his name was being included in the history sheet, this Amanatullah Khan, which is the MLA of AAP, he got to know from social media, and then he petitioned the Supreme Court of India, challenging that his particular name should not be included in the history sheet of that particular police station. However, the Supreme Court, what it did is that it rejected the petition made by this particular MLA, claiming that whatever the police is doing is lawful, and it is governed by the legal provisions of the Police Act, that if a particular person is facing any kind of activities or any kind of criminal charges and multiple criminal charges and through a temporal phase of his own particular life, then he should be legally viable to be included in the list of history sheet. So the Supreme Court rejected its petition. However, the Supreme Court cautioned all the state governments, not only of Delhi but also across the state governments of our country and the union territories, that it should direct the police to create history sheets in such a manner that the language which is being used in the history sheets, it should not reflect the prejudices or discriminatory approach and attitude towards a particular caste or towards a particular religion. And through this thing, we should be able to know what are the major issues which is associated with like documentation of such kind of a history sheet. So the first thing which is problematic to it is that it is deprecating and like demolishing the privacy of a particular individual. Since the history sheet is containing a lot of data which is with respect to the personal data, their financial data, their data of their properties, their data of their friends, families, etc. So it breaches the right to privacy of a particular individual, which is protected by Article 21 of the Constitution. Secondly, what is more important to note over here is that since everything is available over the public and everybody has access to some kind of history sheets, or at least the police department has access to the entire history sheets, so it basically diminishes the self-respect and dignity of that particular individual and also of the family members of those particular individuals. And the third important aspect we need to mention over here is of political vendetta. That, for example, it might be a possibility that the ruling party might utilize the tool of history sheets to name the opposition MLAs or any political candidate of the opposition party to be included in the history sheet by utilizing the force of police, so that they can achieve the political vendetta. And as we know, we already noticed that whenever a person has been declared a history sheeter, they have to pay a regular visit and a frequent visit to the police station to actually ascertain and authenticate their identities, and they need to make sure and assure the police that they are not further indulging and involving in any kind of criminal activities. So this was all for the entire holistic discussion of history sheets. Now, as we are living in the age of consumerism, every industry or every company is trying to sell a certain product. And to sell that particular product, what these companies are using, the tool of advertisements. And these advertisements become a very potent tool which shapes the consumer choice and influence the consumer behavior. And in this topic, which is Advertising Standards Council of India, we are going to discuss exactly the same issue of misleading advertisements and what are the functions which are actually done by the Advertising Standards Council of India. So from the picture itself, it is quite sure, very clear, that whenever we are advertised about a particular subject, say burger, so it looks quite elegant and very attractive to us. However, when we go to that particular shop to eat that burger, we get this burger, which is very, very dry and very bad looking in reality. And this is what we call as misleading advertisements. So we need to understand that why we are trying to study Advertising Standards Council of India and its functions now. And the context is very clear. So recently what had done is that the Advertising Standards Council of India, ASCI for short, now we'll be calling it ASCI itself, it basically processed complaints about 101 ads featuring various celebrities and influencers, celebs and influencers, and these ads were breaching the code of advertisement, which is propounded by the Advertising Standards Council of India, or ASCI for short. So as we know that the advertising is a very important and potent tool to shape consumer behavior and public choices or consumer choices. And whenever a celebrity is trying to promote any particular product, it has altogether very disproportionate effect on the influence on the consumer behavior, and the consumer is more inclined to purchase that particular product. And that is why it is very important that whenever the celebrities or some influencers which have got more influence over the society, when they promote a particular product or a service, they should be very responsible and conscious about what kind of product they are actually promoting, and they should be aware of what kind of possible ramifications or impact of that product on the society in medium to long term. And similarly, so the celebrities are bound both by the code which is provided by the ASCI and the Consumer Protection Act of 2019, that they should be promoting the products in such a manner that they should be absolutely aware and they should be conscious of what kind of impact and ramifications that product is going to create in our society, not only in short term but also in the long term. And it has been observed that majority of the celebrities, they are not basically much more aware about what kind of products that they are actually promoting, and they just run after money to promote any particular kind of product. So before we actually go on and discuss the various functions which the ASCI is trying to do to actually diminish the impact of misleading advertisements in our country, let us try to understand what do we actually mean by advertising first. So advertising is nothing. Advertising is an act. It can be very simply defined that advertising is an act of promotion. Promotion of what? Promotion of a particular service or a product to achieve what? To achieve the attention of the potential consumers, so that the consumers will be able to purchase that particular product. Now, to perform that advertising activity, what happens is that in the pursuit of selling more and more products, what does the advertisers do, or the advertising agencies does, is that they keep on creating such kind of ads which exaggerates or misrepresents the various characteristics and nature and scope of the particular product that they are trying to sell. And in that case, this is what is called as misleading advertisements. That is, it is such an act of selling or advertising a particular product which misrepresents or create a deception in the minds of the users by misrepresenting the major values, characteristics and properties of that particular product. And whenever this misleading advertisement is being received and consumed by the consumers itself, it might be a very great probability that the consumers will be swayed away by the deceptive and the wrongful information, and ultimately it will influence the consumer choice and the consumer behavior. So from that thing, we need to understand that what is the impact of the misleading advertisements. So at first instance, whenever we are trying to analyze this particular thing, at first instance it will appear to us that okay, it is unethical in nature. It is quite unethical that whenever a misleading advertisement is there, it is exaggerating the various characteristics and features of the product, which is wrong and which is dishonest in taste. So it is unethical. But are there any other harmful impacts of misleading advertisements? So yes, definitely there are harmful impacts of misleading advertisements. And first is that it distorts competition. It distorts genuine competition among the advertisers or among the product developers. Secondly, it impinges on the consumer rights. And these are the major two prominent impact which misleading advertisements create. And that is why the entire industry, advertising industry in 1985 led to the creation of Advertising Standards Council of India, so that it can actually inhibit the presence and the prevalence of misleading advertisements in our country. So now let us try to understand about the Advertising Standards Council of India. So it is a independent and self-regulatory organization. It is an independent and self-regulatory organization which was created in the year of 1985 by involving and coordinating the various stakeholders of media, advertising agencies, with an objective of to create the advertising space in our country, free from misleading advertisements. So that was the primary idea or vision behind creation of Advertising Standards Council of India, and it was created as a non-profit organization since it was registered under section 25 of the Companies Act of our country. Now, we are very clear about the vision of the ASCI, that is, it wanted to create such kind of advertising space in our country which is devoid of any kind of misleading advertisements, and it should create a culture where all the advertisers and media agency, they actually create such kind of advertisements which are very honest, fair and decent. So now let us try to discuss the various objectives which are there, which the ASCI has to fulfill. So the first objective it has to provide is the creation of a code, and the ASCI has created a code for ethical advertisements or to curb the misleading advertisements, and every advertising agency or any media agency has to comply with this particular code, or they will become liable to gain complaints against those particular ads. The second important objective which the ASCI has to follow is that it has to create a regime of self-regulation so that whatever ads are being made in our country should be honest, fair and decent, that it should not be offensive to any particular class of person, groups or community. The third important objective which the ASCI has to follow or achieve is that it should maintain that the consumer rights regime provided by the Consumer Protection Act of 2019, it should be protected at any cost. And the fourth objective which the ASCI strives to achieve is to create a level playing field for all the stakeholders which are actually participating in this particular sector. The stakeholders can be media agencies, stakeholders can be various advertisers or the manufacturer of the various products and services who wants to advertise their particular products, and various kind of market research organizations as well, which provides various kind of these market research organizations are such organizations which provide very crucial and critical data with respect to the consumer behavior across space and time. And now let us try to come to the point of what are the major functions which are being provided or achieved by the ASCI. So the first important function which is done by the ASCI is regulating ad content. As we know that one of the major objective of ASCI is to promote a self-regulation of ads in our country. So the first function which flows from the self-regulation is the regulation of ad content, so that all the ads are safe, decent and fair, and every media and advertising agency which is creating those ads should adhere to the code which has been created by ASCI. The second function performed by the ASCI is that it suo motu monitors the various kind of ads which are prevalent or broadcasted in various media, whether be it social media, whether be it on newspaper or in television. So what ASCI does is that it suo motu and very proactively monitors the standards and various kind of ads which are floating across the various layers of media with the help of very high-tech technologies like artificial intelligence, etc. and machine learning. And with the help of such technologies, they are able to monitor the such large scale of advertisements which are being created in our country. The third is pre-production advisory services. As we know that ASCI is trying to establish a self-regulatory regime so that whoever the media agency is and they are creating advertisements, they should be first of all at the stage of content creation of that particular advertisement itself, they should be able to have an idea that whether their ad or advertisement which is going to be created, it is going to be ethical or it is going to be a misleading advertisement. So what ASCI does is that it provides pre-production advisory services to various advertisers and media agencies, so that to help mitigate the risk of creating such kind of advertisements which might fall into the category of misleading advertisements. And the fourth important function which is performed by the ASCI is that it looks into the various kind of complaints with related to misleading advertisements, whether be received by consumers or consumer organization or by any private player or stakeholder or by the government itself. So one of the most fundamental function which has been performed by Advertising Standards Council of India is to receive complaints against misleading advertisements and to actually understand and analyze those complaints, whether these particular advertisements are breaching the code which has been propounded by ASCI or not. And if it finds that this particular ad is breaching and is misleading in nature, then it tries to flag it and it reports to the government authorities, the relevant government authorities, that is the Central Consumer Protection Authority, to take lawful action against those particular advertisements and media agencies. So this was all for this particular topic. And as we know that if we need to establish a very strong consumer rights regime as has been propounded by the Consumer Protection Act of 2019, it is very important that the Advertising Standard Council of India has to play a very proactive role in bringing in line all the various stakeholders which are present in the ecosystem, so that the number and the scope of misleading advertisements, it decreases in time. So recently, the Prime Minister's Economic Advisory Council has released a working paper by the name of Share of Religious Minorities, a Cross-Country Analysis from 1950 till 2015. Now, this report had gained a quite lot of traction in the media. But before we go on and discuss the various findings and issues associated with the particular report, let's try to understand what do we actually understand by the term called Prime Minister's Economic Advisory Council, or what is this body called and what are its various functions and how is it constituted. So, Prime Minister's Economic Advisory Council, it is a non-constitutional, non-statutory and non-permanent body. So you might feel that, so how it is created? It has not been created by constitution, it has not been created by any statute. So it has been created by an executive resolution. And for what purpose it has been created? It has been created to provide recommendations to the Prime Minister for certain important macroeconomic issues. Now, the Prime Minister Modi, it created his first Prime Minister's Economic Advisory Council in the month of September 2017. Before that, it was headed by C. Rangarajan, an eminent economist of our country, who was serving as an chairperson of the Economic Advisory Council for the Prime Minister Manmohan Singh. So, with respect to the composition of the PM-EAC, it comprises of a chairman and a set of eminent economists. So, right now the chairman is Mr. Bibek Debroy, and it comprises of a lot of eminent economists like Shamika Ravi, who is also one of the co-authors of the working paper that we are going to discuss in this lecture. And about its administrative arrangement, so Niti Aayog serves as the nodal body for all the logistical and administrative support which the PM-EAC is required. Okay, now coming to the term of reference of the Economic Advisory Council of the Prime Minister. So primarily it performs three very important functions vis-a-vis the various important issues in the country, and it reports to the Prime Minister of our country. So the first important thing is that it analyzes any issue, whether it can be an economic issue or it can be some other issue as well, referred to it by the Prime Minister and advising to the Prime Minister thereon. Second important function performed by the PM-EAC is addressing issues of macroeconomic importance, which could have been referred to them by the Prime Minister, and they can also take some suo motu efforts also, so as to analyze various macroeconomic issues which are prevalent in our country. And third task which is performed by them is that they have to attend to any other task which is from time to time which has been delegated to them by the Prime Minister's office. Now, since we are done with understanding with various facets related to the Prime Minister's Economic Advisory Council, now let us jump to the main topic, that is the working paper which was being published by the Prime Minister's Economic Advisory Council, or PM-EAC. So what was that particular report? So the report was titled as we already discussed, that report was titled as Share of Religious Minorities across country analysis. So what this report had done, or what was the scope of the study, was that the experts who were actually curating this particular report, they tried to understand how does the religious demography of different countries, for instance, in this report they tried to study the change in demography of 167 countries. And what these experts they try to study is that how in these 167 countries the share of various religious groups is changing with respect to a group which is called the majority religion group, and how the share of minority religious groups are changing over time from the time span of 1950 till we reach 2015. And based on that particular data, they are trying to come into some kind of conclusion with respect to what kind of environment or conducive political environment a country is able to provide to their minorities, which we are going to discuss in the coming slides. However, before we go on and discuss the various findings and the conclusions made by this particular report, we need to understand one very important thing. Why did the PM-EAC chose this topic at the first place? Why did various experts like Shamika Ravi in this particular case chose to study the change of religious demography? So if they have chosen this particular topic to study and they are tracking the compositional changes which is happening across the space and time in various countries across time, so we need to understand that it holds a very important concept, and that is why they are trying to unfurl and study that particular thing. So what we need to understand over here is that how does the religious demography of a country impacts the various socio-political and economic dynamics which are going on in that particular country. And that is the core essence of studying that particular working paper. So how does the religious demography or the religious composition of population of a particular country impacts the socio-economic political dynamics of that particular country? So let us try to understand it point by point. So the first point which the religious demography defines is what kind of social and cultural identity is being shaped by the composition of the religious composition of the population of a particular country. For example, whenever a particular country, imagine a country having a population of only one religion, and it is that particular one religion group or social group having that particular religion is the majority community. So ultimately the entire population of that country will be developing an identity which is based on the various values, traditions and customs which is propounded by that particular religion. And that is why the compositional mix of religions within the population of a particular country is a very potent parameter which determines the social and cultural identity which a particular person or a citizen of that particular country it assumes. It basically manages and it basically provides a view that how that people of that particular country see themselves and see the other persons who are belonging to some other religion. The second important point we need to note over here is that how religious demography influences the political landscape What do we mean by the political landscape? Is that how the nature of state is being governed by the religious demography. Let us try to understand it with the help of a very simple example. Now assume that there is a place which is dominated by such kind of community which does not eat meat. So the people or the community which is being living in that particular area, they are following one particular religion, and the religion is commanding them not to consume meat. Now, if these people are in majority in that country, these people will try to impose their religious customs and traditions into the legal form, that is into the laws, and that is how the religious demography or the composition of the religious majority and the religious minorities and the mix of it tries to alter the political landscape, and it tries to manifest itself in the form of various kind of laws and various kind of policies and the political ideologies which the government or the state of that particular country might adopt. So this is the second most important point that we need to keep in mind over here. The third point that we need to focus over here is the fiscal policy. Fiscal policy or the resources of the government. So as we know that if there is a religious minority, and minorities are usually subjected to discrimination, ostracization, and they are not able to participate in the process of economic development, and usually it has been found across the globe that whenever there is a minority, whether be it on the basis of ethnicity, whether be it on the basis of race or religion or caste, minorities are left behind in the race of economic development. And with respect to that, if we understand what kind of a religious demography is present in any particular country, our governments and the state will be able to design better policies so as to determine what proportion of resources of our country should go to which section of our population. And that is the major important point that we need to note over here, is that the significance of religious demography, that it is very important for the policymakers to actually understand that how does the demography is shaped and how the composition is changing, not only spatially but also temporally. Now let us try to, since we have established the premise of the study of that particular report which has been published by PM-EAC, now let us try to find out the various findings which have been provided by the PM-EAC report. So what it had found, that after researching and analyzing the data of 167 countries all across the world, what it found, that in majority of the developed worlds, majority of the developed democracies or the OECD countries, that is usually the Western European countries, it found that the majority population, that is the population is showing a declining trend all across the world. Okay. And it has been quite evident in countries like Britain, France, Germany, etc. Now, second important finding that comes from our neighborhood itself, from South Asia. The report suggests that in South Asia, the entire majority community population is increasing. So the countries like Pakistan, Afghanistan, Bangladesh, Sri Lanka, even Bhutan. So what the report is suggesting, that the majority community population, or the population of the majority community, or the community which is following the religion which is having the largest population, is increasing in South Asia. Okay, so what we are able to see over here as compared to the global observation and the observation in South Asia is that whenever there is a developed democracy or there is more liberalism in a democracy, it is providing space for the minorities to increase their share of population in these countries, and the majority population and the share of majority population is decreasing in the developed countries or in liberal democracies. However, in South Asia or in our neighborhood, which is usually comprised of theocracies, that is state constituted on the basis of religion, What is the observation of this particular report? Is that in countries like Pakistan, Afghanistan, Bangladesh, which are very Muslim dominated, and most of all these are theocratic in nature. That is, these are not secular in their state credentials. So what the report has identified, that the majority population is increasing and the minority population, the share of minority population is decreasing in these countries. And based on these two observations, one of the major conclusions which this report is trying to address is that it suggests that whenever a country shows that the share of majority community population is decreasing and it is in tandem with minority community population increasing, it points to the fact that the kind of democracy that this country has established, or the developed countries has established, is quite liberal in nature, and it is providing appropriate opportunities for the minorities of that country as well to actually participate in the various avenues of economic growth and development, so that such liberal democracies are creating such policies of redistribution of wealth that the minorities are also being given their own dues, so that they will be given proper opportunities, resources, facilities, infrastructure to participate in various processes of economic growth and development, and which leads to ultimately reflects in the demographic nature of that minority community population, that when they flourish, it will result into more population growth of that particular minority community as well. However, the same thing which was visible in the developed countries or developed democracies of the West, especially in the Western Europe and the Americas, it was quite a starking contradiction when we came down to the South Asia, which basically comprised of countries which are theocratic in nature and are showing a tendency where the majority community population is increasing and the minority community population is decreasing, which is also indicative of the fact that these countries are less tolerant to their minorities. This is the prime central argument behind this particular report which has been published by PM-EAC. Now, what is the basic finding with respect to India? So, with respect to India, it showed that India is also traversing in the path of developed liberal democracies of the West and the Western Europe. So, what the report had found out for the India, that the majority Hindu population share has decreased to 7.82% and the Muslim population share in the entire population has increased by roughly 45% in the time span of 1950 to 2015. Now, this finding ultimately it created a lot of media attention, because it was not the intention of the report which was published by the PM-EAC to provide such kind of data. However, there was a ruckus created in the media that by the communal and the soft communal politics and majoritarian politics of our country, is that the Hindu population has decreased. However, the Muslim population has increased by 45%. However, that is not the particular case. It is not the absolute number in which the Muslim population has increased. It is the relative increase vis-a-vis the percentage of the proportion of population which the Muslim community had in the year of 1950. Let us try to understand it. What does this particular number suggest? So, what had happened is that the Hindu population in 1950, it comprised of almost 84% of the total population, and in 2015, it comprises to 78% of the total population. The same ratio goes for, like, it was 9% for the Muslims. For the Muslims, in the year of 1950, Muslims contributed to only 9% of our entire population. However, in 2015, it comprises of 14% of our entire population. So, what the report had suggested is that from the jump the Muslim community had made from 9 to 14%, it comprises of a jump of 45% relative to these two things, and similarly a decrease of 7.82%. So it was a perfect textbook example of misrepresentation of data, which was utilized by communal agents in our Indian politics to actually show a particular community in bad light with respect to their fertility rates and the population of that particular community. So that is why we also, as a very vigilant citizens, we also need to understand that how that data is represented is more important than the data itself. So sometimes with the change in the context, the entire messaging of that particular report also changes. And that is why, because of such kind of messaging, since it was misrepresented in the media, the Population Foundation of India, which is one of the most foundational think tank working in the field of demography, it also provided an advisory requesting all the media agencies to not to misinterpret the data which has been provided in the particular report. This PFI is Population Foundation of India. Now, this is the major argument or the central argument which was present there in the report itself, that whenever the majority community population share starts to decrease in that particular country, with respect to the minority population share also increasing at the same time, it shows what kind of a liberal atmosphere that country is trying to provide for its own minority populations or minority citizens, so that they can become a better participant in various modes of economic processes and economic growth and development. Now, the next topic that we are going to discuss is the floor test. This topic is not unusual and keeps on recurring in the newspapers and various media. So now let us try to understand what do we actually understand by the term floor test. Before we go on and discuss the concept of floor test, what is the context behind it? So recently, the BJP government, which has been constituted in Haryana, the 3 independent members which were supporting the government, they have withdrew their support, and this has called for a floor test, so that the leader of that particular government, it should come to the floor and it should tell the entire legislative assembly that he or she governs the confidence of the legislature. So now, what is floor test? As we know that India follows a parliamentary form of government. India follows a parliamentary form of government. And what is the fundamental principle of parliamentary form of government? That executive is collectively responsible to the legislature. Why? Because it is the executive which usually a subcommittee of the legislature itself. So executive comes out of the legislature, and that is why executive is responsible to the legislature. And the floor test, which is also called the trust vote, this floor test or trust vote is nothing but a way of determining whether the executive is actually enjoying the confidence. Trust vote is a way to establish whether the executive is actually enjoying the confidence of the legislature. Now, what do we understand by the term confidence? It does not mean like the cognitive confidence or a feeling that, okay, that person is fine. Here, in parliamentary parlance, this confidence means that whether the executive which has been formulated by a particular political party which is governing the majority in the legislature, if this executive is having the majority support in the legislature or not. And that is why, to actually identify and authenticate whether the executive is having the majority support in the legislature, to ascertain it, the trust vote or the floor test is conducted. Now, when is this floor test is required to be conducted? So it is basically required in 2 basic conditions. So whenever the situation arises where the executive, where people feel that the executive do not enjoy the confidence of the legislature, which basically means that the party which has formed the government is not having the majority support in the legislature itself. And that is why there is a need to go for floor test. The second important condition where floor test can be called for is when there is a coalition government and there is a shifting of the coalition alliance. It might be a possibility that two political party came into a coalition agreement that they will be forming a government. In middle of the course of the government, one of the coalition partner thought that, okay, I will not be able to continue with this particular government. So ultimately that particular government will not be having the majority support within the legislature because that coalition partner withdrew their support. And that is why in these two primary cases, it is required that there has to be a floor test to actually ascertain and determine whether the executive of the day is enjoying the confidence of the legislature or not. Or in other terms, whether the executive or the political party which has formed the government is enjoying the majority in the legislative assembly or not. Now the next question is, who can call for the floor test? So it can be called for by speaker when the assembly is in session. And on the other hand, it can also be called by the governor of that particular state when the assembly is not in session. That is the primary distinguishing factor that we need to note over here. And what happens during the floor test? So whenever a government is being called or a CM of a particular state is being called to provide a trust vote, what happens is that the CM of that particular state or the leader of the house, it basically moves a trust vote, and every member who are present and voting over there, they need to support that particular trust vote if they want to show confidence in the government positioned by this particular CM. So if this trust vote gets the majority, that particular government will survive. And if in other hand, if it loses the majority, and if nobody, like if 100 persons are present over there, and if it will receive only say 49 votes, so definitely it is in minority, and ultimately the CM has to resign and the government will fall. Apart from it, there is also one more important concept that you should be knowing, is the term of composite floor test. So what is this composite floor test? Composite floor test happens in a situation when there is no unique majority in the assembly. So for example, there is an assembly comprising of 100 seats. We need 50 seats to win or to form a government in that particular assembly. So there might be a possibility that there are three elements of say 40, 40 and 20. Now there might be three elements of 40, 40 and 20 seats in that particular legislative assembly, and composite floor test is held in certain situations or in such situations where there is no one particular person who claims to be forming the government. So when is this composite floor test is being held? When there is no one candidate who is claiming to form the government. Or in other terms, we can also say it like it is under such situations where there are more than one candidates who claim that they are going to form the government. This is the primary concept which is related to the composite floor test, and this is what is all relevant in this particular topic. In the recently concluded general elections to constitute the 18th Lok Sabha, one very interesting thing happened. Two candidates who were lodged in the jail, they were able to contest the elections, and they were not only able to contest the elections but they also won. What I am talking about is one candidate by the name of Amritpal Singh, who won from the Khadur Sahib seat in Punjab, and second is Sheikh Abdul Rashid. Sheikh Abdul Rashid, who won from the constituency of Baramulla, where he defeated the ex-chief minister of Jammu and Kashmir, that is Omar Abdullah. So, with respect to these things, we need to discuss in this particular article that what does the law says about the voting and contesting right for elections of the prisoners. So now let us try to go into more depth. So can a jailed person contest elections? As we already noticed in the context of this particular discussions, that the two important candidates, that is Amritpal Singh and Sheikh Abdul Rashid, both are in the jail facing criminal charges of terrorism against them. They were able to contest the elections. But what does the law say about it? Okay, so to get to the answer of can a jailed person contest elections, we need to look at section 8 of Section 8 of RPA Act of 1951. What does the Section 8 says? Section 8 says that it provides for disqualification of any individual from contesting elections. If they are convicted. The keyword over here is convicted. If they are convicted or found to be convicted for certain offenses like dowry, bribery, etc., or any other crime which provides for imprisonment more than 2 years. And in that case, that particular individual will be getting disqualified to contest elections. So that any particular person who gets convicted for any kind of crime for which the imprisonment is more than 2 years, and specifically for the crimes related to corruption, bribery, or the crimes which related to which promotes enmity between two groups or which promotes social evils, if any person is getting, or any person or individual is getting convicted for such kind of crimes, that person will get disqualified to contest elections as per the provisions of Section 8 of RPA 1951. However, what important thing we need to note over here is that the term uses convicted. So, if a person is lodged in jail, there are two kind of person who are lodged in jail. One is a convict and another is an under trial. So, according to the Section 8 of the RPA, it provides that the convict will not be able to contest the elections for either for the Lok Sabha or state legislative assemblies. However, if there is an under trial, they will be able to contest. However, apart from making the particular individual disqualified from contesting, what the RPA Section 8 also tells that as soon as a person gets convicted, and if that person is an MP or MLA, they gets disqualified from the moment itself, and the disqualification continues till the entire term of their imprisonment. Plus, as soon as they will be released from the imprisonment after serving their term of prison, they will be disqualified again for the coming 6 years. So, as soon as a person gets convicted, from the time of the conviction, they gets disqualified. While they are in the jail, of course they are disqualified, and even after coming out of the jail, they will be remaining disqualified to contest elections for parliament or state legislative assemblies for again another 6 years. But is there any exception to this 6-year rule? Does the RPA provides for any kind of provision with which Election Commission of India can reduce this extended tenure of 6 years of disqualification for any particular convict who has served his prison term? So the answer is absolutely yes, and the answer lies in Section 11 of the RPA Act of 1951. So if we'll closely understand the Section 11 of RPA 1951, what does it say? RPA 1951, it provides the power to the Election Commission of India to either suspend, reduce, or absolutely revoke what? This duration which a particular person, that is 6 years, which a particular person has to serve as a disqualified individual to contest elections after they have come out of the prison or after they have come out of the jail. So this section 11 of the RPA, it provides Election Commission the power. It's a very great power and it's quite discretionary in nature. That Election Commission, if it feels that there reasonable conditions exist or reasonable circumstances exist that a particular person has to be provided better opportunities to contest the elections, then Election Commission in that particular case can suspend, reduce or even revoke the 6-year period which a particular person had to serve being disqualified to contest elections. Has there been any case in our Indian political precedents with respect to it? So definitely there has been multiple cases, but for the sake of this lecture I am trying to give you the most recent one. So recently what had happened in the 2019 elections to the State Assembly of Sikkim. So presently the Chief Minister of Sikkim is Prem Tamang, and Prem Tamang was convicted for offences of corruption and graft in the year of 1996. So ultimately when he got the conviction in 2016, he was serving 2-year term from 2017 till 2018. So naturally, when he came out of the prison in 2018, the Section 8 provision of 6 years of entrenched disqualification was still applicable for Prem Tamang. However, what Election Commission did at that point of time, that they reduced the disqualification period of 6 years for Prem Tamang from 6 years to just 1 year, which made him eligible or qualified to contest elections for the state legislative elections of Sikkim. And eventually this particular guy became the chief minister of that particular state. Now this was related to the right of prisoners to contest elections. But what about the right of prisoners to cast their vote? And the answer to this particular question lies in the section 62 clause 5 of the RPA Act of 1951. What does this particular clause says is that no person shall vote at any election if he is confined in prison, whether under a sentence of imprisonment that the person has got convicted, or transportation or otherwise, or is in the lawful custody of the police. What does the second clause says? Provided that nothing in this subsection shall apply to a person subjected to preventive detention under any law for the time being in force. So what does this article properly says? That whenever a person is in lawful custody, that whether if a person is in jail, now a person can be in jail in two conditions that we already discussed: if he is under trial or he is convicted. So the section 62 clause 5 is quite explicit with respect to that if any person is lying in lawful custody, whether be he is under trial or convicted, they are not allowed to vote. Apart from that, if a person is being held under preventive detention, they will be able to provided the opportunity to cast their particular vote, and that is also quite explicit in the law. However, one very important facet we need to note over here. There is a lacune in this particular act which we need to note, that for example, if a person, whether he is an under trial or a convicted, if that person gets a bail from the judiciary and if he comes out and if he is on a bail, then he is definitely not confined in a prison according to section 62 clause 5 of the RPA. And if that person, while on a bail, he is not confined in a prison, so the 62 clause 5 is not applicable to that particular person, and that person who is out on a bail will be able to cast their vote. And that is what the major bone of contention in this Anukul Chandra Pradhan versus Union of India 1987 case, where the Anukul Chandra Pradhan, he suggested and he petitioned to the Supreme Court of India that it is quite unethical and it violates the right to equality. Violates the right to equality of any individual, that if a person is lodged in a jail, he is not able to cast their vote, but if the same person is out on a bail, he is able to cast the vote. So it does not go with the proper legal logic. However, the Supreme Court entertained the petition but ultimately rejected the petition, saying two very important points. First of all, Supreme Court noted that the right to vote is not a fundamental right. Right to vote is not a fundamental right, and it is a statutory right. And since it is a statutory right, it is applicable to statutory limitations which has been provided by the statute itself. And the statute which we are concerned over here is the Representation of People Act of 1951. And the second important argument which was provided by the Supreme Court in this particular case was that the Supreme Court highlighted the state capacity or the limited state capacity of the Indian government, that they will not be able to organize such kind of facilities where the various kind of under trials will be also provided the opportunity to cast their vote. And from the examination point of view, the various kind of details that we discussed in this particular case is very important from the examinations point of view. As the general elections also concluded very recently, it might be a possibility that a question might come up in this prelims only, which is going to happen in the 16th of June. So this was all for this month's Polities in Depth, Recitals in Depth. Thank you and stay tuned for the next month.